time, and we had some requests. I will say that we are going to start today with Mr. Aganoff. Is that right? That's his name, right? We'll hear from Mr. Andoff, not right now. And I think we have a couple of people that have asked to be heard. But prior to that, we have our president of the Senate, who is here, that has an interest in this legislation and interest in this committee. President and Senator Alexander from Oconee County. We'll give him an opportunity to be heard. Mr. President.
Thank you, Mr. Chairman and members of the committee, and I'll be brief with my remarks. Thank you for having this subcommittee this afternoon and the other work of the subcommittee. S533 is a bill that certainly has been around, trying to address what the joint and several aspect of things that we had addressed for those that were here in 2005 that we thought had been settled and had been addressed back to the system that had worked from 2005 into the Supreme Court decision in 2017. And that is accountability for individuals for their actions, and also that you're responsible for your actions in an amount that is considerable related to the amount of the accident that you caused. And so I think as I've reread and re-looked at the Supreme Court decision and looked at our statutes, certainly that is what the focus of this is. I appreciate your attention to it. It is important, obviously, to the state of South Carolina. I think there was a lawsuit, if my memory serves me correct, over in the state of Georgia as well, very similar to this, and their General Assembly acted on that within the last year, 18 months or 2 years. And so again, I appreciate your attention to this and look forward to it working its way through the legislative process in a hopefully a timely manner. So thank y'all. Thank y'all again.
Thank you, Mr. President. Any questions of the Mr. President? Okay. Thanks for being here, and you're welcome to stick around and pull up a chair if you like. If you have a question, you raise your hand. We'll recognize you. Okay, so this is a continuation from the work that we've had. I will say that Sharon and the rest of the staff have done a pretty good job. We had a lot of questions that were raised at the last meeting. The insurance director is unable to be here today or is not here. And I think there's anybody from the Department of Insurance that's here that's able to end up speaking in his stead, or just Julia, I see you're here. Raise your hand. You want to be heard today, Julia? No? Okay. We didn't find anybody else from there that was coming over either. You got any other staff people here? Okay. And so without further ado, we will go ahead and hear from Mr. Angoff, who is hired by SCAJ to talk. He came in last time and spoke a little bit, but he's coming back again to sort of give us a presentation. Is that right?
That's right, Mr. Chairman.
Okay. Can you hear us? Can you hear us? You got your button pressed.
Can you hear me?
I can hear you now. Okay. Are you ready?
I'm ready.
Okay. Would you raise your right hand? Swear to tell the whole truth, nothing but the truth, so help you God.
Yes, I do.
Okay. Please proceed.
Mr. Chairman and members of the committee, thank you for having me back. I'm Jay Angoff. I'm a lawyer in Washington, D.C. I recently retired from my law firm, although it's a soft retirement. I'm still working on certain cases and I'm still consulting on certain matters, one of which is this. I formerly served for 6 years as the insurance commissioner of Missouri, and for 2 years before that as the insurance commissioner of New Jersey. Missouri is a very non-regulatory state. New Jersey is a very regulatory state, so I've got experience in both types of environments. I was asked by the South Carolina Association for Justice to do a report on the likely effects of Bill 533 on liability insurance rates. And I know that liquor liability is a focus of the committee's attention, and so that's what I looked at first. And in connection with liquor liability, what I looked at first was a score given to each state by an organization called the Insurance Services Office. The Insurance Services Office is it used to be a nonprofit association run by insurance companies. Several years ago, it converted to for-profit status, and it's now a publicly traded company. But it has more data than any entity in the country, certainly more than any insurance department or any federal agency. And so it collects data on insurance claims, insurance premiums, all kinds of insurance-related information throughout the nation. And what it does is, with respect to liquor liability, it gives each state a score as to the ISO's impression of its liability environment. And in the slide, we show 0 as the best liability environment from the ISO's perspective, and 10 as the score for the worst liability environment from the ISO's perspective. Now, I want to emphasize that maybe we could have picked better words than best and worst. That's from the ISO, the insurance companies or the bar owner's perspective. From the injured person's perspective, obviously, the best and worst would be reversed. And I did a report looking at the joint and several liability laws in each of the 50 states. I relied on surveys done by 2 major law firms which characterized the law in each state. And I did a correlation between the joint and several liability law in each state and the ISO liquor liability score in each state. And you would expect, I certainly expect going into this, that the states with pure joint and several liability, that is the ones that from the industry's perspective are the worst, from the injured person's perspective are the best, I would expect them to have very high scores. And conversely, I'd expect the states with pure several liability, that is states where a defendant can only has to pay for his responsibility of the injury, I'd expect those to have the lowest scores. But what I found was, and you can see this in my report in table 1 and then graphically in these maps, there really is no correlation. Some states that have pure several liability, that is the most defendant-friendly type of score, the most defendant-friendly law have very high scores. So, for example, let's look at Alaska here on these 2 tables. You see Alaska in red has pure several liability, but its ISO score is green. That's a high score between 7 and 10. And conversely, I don't think anybody wants me to go through all the 50 states, but if you look at the map just impressionistically, you can see there is no correlation. And if you look at my table 1, you can see based on the numbers, there's no correlation. So why is that? And what is the effect of that lack of correlation on the arguments for this bill? If, regardless of what your predilections are, whether you think liability should be restricted or expanded or stay the same, it seems to me it's certainly in the interest of all members to know what the ISO liquor liability score is based on. For example, we can see it's clearly, there's no correlation with joint and several, but maybe there are other legal doctrines that the ISO score is based on. There's all kinds of legal doctrines, obviously, and maybe ISO has done research that enables it, has come up with a formula, an algorithm that enables it based on the law in each state to give the state a liquor liability score, which is very influential on liquor liability rates. To my knowledge, no one outside of the industry, and I'm not even sure that individual insurance companies within the industry have ever seen the formula, if there is one, have ever seen the methodology ISL uses to come up with its liquor liability score.
What would it take to? I heard you say that it has no correlation, but what would it take to be able to quantify it, to be able to determine it based upon the data? What data would you need?
Sure. So you could go through, go through the doctrines, the various legal doctrines that affect liability. Are there caps on damages? What's the legal standards? Is it negligence, recklessness? What's the statute of limitations? Is there a collateral source rule? I mean, you all are familiar with those doctrines, and what may be the case. I'm a little skeptical, but what may be the case, and it is the case, it would be valuable to everyone, that ISO has come up with a formula that gives points to each of these doctrines, and based on those points, comes up with this number. So that's what I would like to see. I would like to see, and I think you all would like to see, how does ISO come up with these numbers? If it has a quasi-scientific way of coming up with them, that's one thing. On the other hand, the other extreme is it's purely impressionistic. That, maybe they call up a couple of insurance agents. Maybe they've got second-year law students doing research on cases. I don't know, but I would love to know. And I have no ability to get that methodology from them. I would think that a legislature might. So that would be my recommendation. And again, I think it's good for both sides of this debate to just find out, how does ISO come up with its liquor liability score? Okay, so that's one thing.
Yes.
So if you go to this chart, which talks about pure loss, pure JNS, 59.1 loss ratio, modified JNS, 71.6 loss ratio. Tell me what a loss ratio is. What does that mean?
Yeah, a loss ratio is simply the ratio between the amount that a company pays out in claims and projects that it will pay out in claims to the premiums that it collects in a year. So if a company has a loss ratio of 70, that means it's paying 70 cents out on the premium dollar.
Okay. Thank you.
So I looked at another data set to try to determine or confirm or non-confirm the effect of what the effect of joint and several liability is on insurance rates and insurance profitability. And that is data collected by the National Association of Insurance Commissioners, known as the NAIC, every year. What the NAIC does is collect data on 19 different insurance lines each year. They do a great job of it. They've been doing it for a long, long time. And they collect premium and loss data on 19 different lines from each insurance company licensed to do business in each state. And one of those lines is called other liability. Other liability includes liquor liability. It also includes more things than liquor liability. So it's a very inexact measure. Unfortunately, liquor liability is a subline, not a line. So the NAIC does not collect data on liquor liability, but it does on other liability. Liquor liability is included within other liability. And for what it's worth, here's what I found looking at the state-by-state data. What I did was compare the loss ratio in South Carolina to the loss ratio in 5 states along the eastern seaboard that had pure joint and several liability, whereas South Carolina has modified. What you would expect if joint and several liability law had a material effect on insurance company profits, you would expect that the state with pure joint and several liability would be less profitable because they're less likely to pay out money because the defendant is only liable for his percentage of the damages. But what I found was exactly the opposite. That in the this happens to show North Carolina, but North Carolina is got the same, just about the same loss ratio as the 5 states, that is Alabama, North Carolina, Virginia, Delaware, Maryland, and those are laid out in detail in my report. And those states have a loss ratio, North Carolina is the example, of 59.1. That means that in North Carolina, insurers paid out 59 cents of the premium dollar for other liability insurance, leaving 41 cents left over for expenses and profit. South Carolina, though, paid out 71.6 cents on the premium dollar, much more than North Carolina. And a 10-point difference in loss ratio is a lot. So we found, not just for 2021, but for the NAIC, in each annual report it does, goes back and tabulates the data for the last 10 years. And the data for the last 10 years comes out the same way. South Carolina is consistently 10 points higher in loss ratio. That means less profitable than the 5 states along the Eastern Seaboard with pure joint and several liability. Now, does that mean if South Carolina enacted pure joint and several liability that it would be more profitable? Of course not. But what it does show, again, just like the ISO data, that there's no correlation between joint and several and insurance profitability. There may well be different legal doctrines in different states. I mean, there are, and they may have an effect on the liability environment. But joint and several liability is not the determinant. So this just shows South Carolina versus North Carolina. North Carolina has pure, South Carolina has modified. Despite that, South Carolina is much less profitable in other liability. The same thing in commercial auto. Exactly the same pattern. I know joint and several liability is an issue in connection with commercial auto insurance. And once again, you see North Carolina with a loss ratio of about 59 cents, South Carolina with a loss ratio of a little over 72 cents.
Mr. Agnoff, would it factor in, though, that in North Carolina, they have contributory negligence, correct?
I'm sorry, Mr. Chairman?
I said in North Carolina, they have contributory negligence. Any percent of negligence gives you a nothing verdict, right?
I don't know the legal provisions of each state, but I'll certainly take your word for that.
Well, so let's say that you don't take my word, and it's true. So they have a different standard than us. So if they have contributory negligence, so if the defendant is if they're not 100% at fault, then they don't pay. Basically, is that your experience?
Plaintiff is 1% at fault.
If plaintiff is 1% at fault, then you don't. So I'm saying, would that have any effect upon your numbers whenever you're doing North Carolina?
Well, that's certainly, I mean, that's part of North Carolina. And so that is the North Carolina loss ratio is a product of that and all the other legal doctrines in North Carolina.
It would make sense then that their loss ratio is less if they have strict contributory negligence. If the plaintiff is 1% at fault, then the loss ratio is lower than when we have a modified version where we're showing, 11, 12% points. So compared with other states that may have modified, the question is that how does South Carolina do?
Sure, I agree. Sure, if they have contributory negligence, that is certainly a substantial factor in making their loss ratio as low as it is, and that makes my point. I think that joint and several liability law is simply one doctrine, and you can't look at that one doctrine and say if you change joint and several liability law, it's going to reduce insurance rates. Yeah, I get what you're saying about contributory negligence. Sure, that makes a big difference.
Sure. Okay. Thank you.
Okay, you remember last time we spoke about this, the insurance department was here and they showed this chart, which shows the combined ratios, and the combined ratio, Mr. Chairman, is a little different than the loss ratio. The combined ratio is the sum of claims payments and projected claims payments plus expenses, both underwriting expenses and what they call loss adjustment expenses. And so the combined ratio is always going to be substantially higher than the pure loss ratio. Anyway, what this shows is, as you can see, is the South Carolina loss ratios just being off the charts. There's just so much difference between South Carolina and the rest of the states. And to me, as I said 2 weeks ago, that indicates that there's something going on here. There's got to be some problem with the data. There's got to be different ways in which the companies have interpreted the survey that the department has sent out. And here, Mr. Chairman, I think the committee, well, the department could do it itself on its own volition, I think, but the committee certainly has the power to do this. It's important to find out exactly what each insurance company is filing, how each insurance company makes its rates. Today, the insurance department does not regulate liquor liability rates. Insurance companies can charge whatever they want. And that's I think that's defensible, but the insurance department should know what each company is doing. And when I was commissioner in Missouri, which also, as I said at the beginning, had a pretty hands-off regulatory system, we nevertheless required insurance companies to file what we called, maybe somewhat euphemistically, informational filings. So we could see what they were doing. And I can't emphasize that they don't make these filings in South Carolina. And I can't emphasize enough to you, Mr. Chairman, how important it is for the department to have these filings, because there's so many different aspects of that which involve a lot of judgment. So let me just give you a couple of examples. There's an actuarial process called loss development, which means the insurance company looks at how much it's actually paid out in the past, and based on that and how much it's paid, based on patterns in the past, it projects how much it's going to pay out in the future. There's another actuarial doctrine called trend. Then they take what they do after they develop the losses, they trend them based on inflation and social inflation. There's a tremendous amount of discretion in what the actuary decides on for the loss development factor and for the trend factor. They also include reserves in what they term their incurred losses. And their reserves, again, are based on a projection. They're not actual payouts. They're based on a projection. They also include investment income, and investment income varies, obviously, based on how the stock market is doing and where interest rates are. Today, the stock market's at an all-time high. Interest rates are much higher than they've been in the past. So that's another thing you'd want to look at. And another thing you'd want to look at is the distribution of the rate. The four things that I've just talked about have to do with the rate level. But there's also the distribution of the rate, meaning in different areas of the country or different areas of the state. How is territory factored in? This was a really sensitive issue in Missouri because Missouri's got Kansas City on one side, St. Louis on the other side, big cities, and most of the state, and then it's got Columbia in the middle, which is where the university is. But most of the state in between those two big cities is pretty rural. So there was always a rural versus city controversy. People lived in the cities, thought they got charged too much. When I was deputy commissioner in New Jersey, there was the same thing, although New Jersey's got high rates because the state as a whole is so densely populated. But one company had its regular rates, and then it had a point system. 4 cities in New Jersey, Newark, Camden, Trenton, and Jersey City, were rated up. They got extra points because that is, people who live there got extra points and got higher rates. So there may be something going on. I don't know this, but there may be something going on like that with liquor liability in South Carolina. And there's an argument. I mean, there are arguments both ways. You can socialize the rate across the state, or in places where the liability is likely to be greater, in places like Columbia, where there's a university and there are a lot of college bars, maybe rates there are higher than they would be if they were if they were socialized across the state. I don't know, but these are things that are in rate filings. Rate filings are really, I don't want to say a lot of fun, but they provide a lot of information. And so I think it's very important to get the rate filings in order to see what's really going on here.
Mr. Chairman, a bill was introduced today in the Senate, Senator Johnson and I and others, to take liquor liability coverage out from underneath the commercial policy exemption.
So you might speak it up.
Oh, I'm
Get
sorry.
closer to your microphone.
I'm sorry. A bill was filed by Senator Johnson and I and others today to take liquor liability out from under the commercial exemption for filings and put it where you would have to file. There would be rate applications, just like car insurance. And what I guess you're telling me is this: if automobile insurance policies, they submit rates, insurance department approves them or disapproves them.
Right.
So if Senator Johnson's driving record is horrible, I'm not saying it is, but assume for the sake of argument, he has driven recklessly between here and Lancaster, or Fort Mill, which